Good evening to all the participants and welcome to the week 4 of the Know Your IP lecture series. Sir, Professor G.B. Reddy sir, the resource person, the expert is here. I humbly request you to please introduce the speaker, sir. Thank you so much.
Very good evening to all the participants. Welcome to the weekly online series of Know Your IP. And today is the fourth lecture by one of the leading practitioners on intellectual property rights by Dr. D. Venkat Reddy. And I have great pleasure in giving a brief introduction before I would request Dr. Venkat Reddy to make his presentation. And Dr. Venkat Reddy is, as I already said, one of the leading IPR attorneys in Hyderabad, Chennai, and even in Delhi. And he acquired his MA, LLM, PG diploma in human resources development, in alternative dispute resolution, in cyber laws and intellectual property rights. And to top it all, he obtained his Ph.D. in law on the topic of trademarks from Osmania University. Before joining the profession of advocacy, Dr. Venkat Reddy worked for Indian Air Force in fighter aircrafts for 18 years. So which probably is the strength of him as a voracious fighter in the courtroom as well. And he enrolled himself as an advocate in the Bar Council of United Andhra Pradesh in 2003, 18 years back. And his areas of specialization include intellectual property rights matters, constitutional matters, the mining related matters, arbitration, criminal and civil matters. And Dr. Venkat Reddy, in fact, practiced and submitted his arguments before various high courts, including the High Court of Telangana, Andhra Pradesh, Chennai, Mumbai, Delhi, Ahmedabad, Aurangabad, Allahabad, and Dharwad, and Supreme Court of India. And till the abolition of Intellectual Property Appellate Board, he used to appear regularly before the IPAB, Chennai. And he is the founder of Messrs. RVR Associates Law Firm with 15 advocates specializing in different fields of law. And this firm has its associate offices in Chennai, Delhi, and Jaipur. And as far as the intellectual property professionals are concerned, Dr. Venkat Reddy is the Vice President of AIPPI India Group, and that is the International Association for the Protection of Intellectual Property, which is based at Zurich, Switzerland. He is also a member of International Trademarks Association, life member of FTAPC, life member of NIHRD, life member of High Court of Telangana Bar Association, Supreme Court Bar Association, so on and so forth. He has an academic flavor, having delivered a number of guest lectures at University of Hyderabad, Osmania University, Nalsar Law University, University Law College, Bangalore, then IPAB Law Colleges, JNTU. The list is very long. And dear participants, you know that intellectual property, mostly in the form of trademarks, has many dimensions. And one of the most important dimensions is the area of passing off and infringement of trademarks. And many, in fact, even stalwarts are not clear about these aspects, like what exactly is passing off, what is trademark. And this is the precise reason why we requested Dr. Venkat Reddy, who has enormous practical experience at the bar, in registrations, and even in the litigation. So without taking much of your time, now I have great pleasure in inviting Dr. Venkat Reddy to make his presentation on trademarks in the context of passing off and infringement. Over to you, sir. Welcome.
Thank you, sir. It is always pleasure, my guru, Professor G.V. Reddy garu, and I learn many. Always, even any time, I am able to touch with him because for any academic doubts I got, and he has been helping me all through. And today I'm standing before you just because of him, and I got my Ph.D. degree under his able guidance. And thank you everyone for today being with me for this session, and good evening to everyone. Now this is one of the interesting and important subject in the present domain, because I am told that already the brief introduction about the trademarks and all intellectual property rights is being educated or taught to you all, and this particular issue, because now the most upcoming subject, especially this part of India, and this passing off and infringement, nothing but violating the rights of the owners who have got the registration of the trademark. Even if it is not registered, also there is a remedy, civil remedy is available to the people whose rights are being infringed or violated by the copycats and who are being imitating the brand names. Now just getting into the subject, because I thought it should be at least you should give you a brief idea, because it also matters when you do not have a proper application being filed. When it ends up in litigation, then these are all things comes into the picture. So I thought it should be some introduction in this part. And basically, of course, this slide I will not be concentrating much on this because this is already being taught to you. And we are only concentrating today about the trademarks. And trademarks is one of the most important aspects of intellectual property rights, for the reason that this is the only one intellectual property right you can have all through your life, all through your time, as long as you renew every 10 years. Unlike the patents comes into the public domain after 20 years of its life, copyrights 60 years and 65 years, and designs 15 years, geographical indications also accordingly, and trade secrets so forth. So why? Because the trademark says, because once the mark is registered, if you keep renewing it for every 10 years with its proper usage, and you would be the owner of this intellectual property rights as long as you own it and as long as you renew it. And in this two important slides is, one is because where it is written TM, SM and R. TM stands for trademark, which is in the process of registration. SM stands for service mark. We will be discussing in the slides what is trademark and service mark. R is one issue, because if you are putting R in a circle at the right side top corner of the trademark, not being registered, then it is a punishable act. So now this is the only issue, because now time is given very short, 45 minutes is too less time to explain this subject. Now I will not be concentrating any of those other aspects, and I will be directly getting into the subject. Now, one of the important slides which I thought it is very important, because we have to understand while going for the registration of the trademark, what are the parameters to be taken into consideration. Because when somebody files a passing off or infringement suit against the violators or the defendants in the case, then you could be feeling that these are the important parameters might have not been taken into consideration that might lead into the litigation. Now, some of the topmost brands, at least I consider, is the Xerox, is such a brand name. It is a coin brand name. The reason I say, because you go to any of the shops all over India, all over the world, there will be the shop name could be written so and so Xerox shop. Nowhere it could have been written the so and so is a photocopy shop. So why I want to say this, because Xerox has become synonym to the particular photocopying mechanism. Accordingly, one of the famous product of the Indian product is the Dalda. So these are the very famous brands. Once by virtue of its quality and usage, these brands have become synonym to its quality product or services. Accordingly, some of the famous brands, just I put it on the slide, is the Coca-Cola, Microsoft, IBM, Apple, and all these brands. See, you are aware that today the brand worth of the brand of Apple is $100 billion. It's not the company you are going to purchase, it's the brand you are going to purchase. If you want to purchase the brand by way of assignment, then it could be costing you $100 billion. So whole concept is, today the most of the people, after understanding the intellectual property rights, it should not be a hard worker, it should be a smart worker. You invent something and leave it in the market, and you can have a revenue of your own, even for next generation also. See, one of the topmost intellectual property owner is the J.K. Rowling, is the author of the Harry Potter. Her income is 2,700 crore rupees per annum, just because she has created a copyright over the book, and by way of royalty she gets is today 2,700 crore rupees per annum. Now coming to this topic, now while filing of an application for the registration of the trademark, I am not getting into the details of what is the methodology and how you will go for the procedure for registration of the trademark. There's a completely different domain of subject, at least we can't cover in this today's session. Now, the most important aspect is the mark should not be descriptive, it should be distinctive. When I say distinctive, mark should be coined. When I say coined, because generic names cannot be taken up for the registration, and there is also a restriction on the names which can be taken up for registration, like which are names reflected in the Emblems and Names Act, and like Mahatma, Buddha, Ashoka, likewise. And also there is a restriction of international non-proprietary names as per section 13 of Trademarks Act 1999. While somebody is making an application for the registration of the trademark, these aspects to be taken into consideration. First of all, the mark should be distinctive, it should be coined. It should not be descriptive of the activities which you are doing. And second issue is that you cannot take up the names of the generic names, even if you take up the registration of the generic names which are registered even, and it should have unless it has a secondary meaning in the market, you won't get the protection for those names. And names which are restricted as per the Emblems and Names Act, and also the names international non-proprietary names cannot be taken up for the registration of the pharmaceutical industry. So here the two kinds of, after the amendment to the act, unlike the earlier act, Trade and Merchandise Act 1958, there is the service marks are added in India. The goods falling under class 1 to 34 are considered as the trademarks, and 35 to 45, whatever the services which are falling in that category could be considered as the service marks. Accordingly, there is something like collective mark, where under one umbrella of the brand name, you get several brand names. And second one is the certification of mark, like government certified marks like wool mark, FPO, and hallmark for the gold. And when you want to purchase particular quality of the wool, people prefer for the certified mark of the wool mark certified by the government of India. And another aspect, when you take up for the registration of the trademark, you should also look into the fact that are there any trademarks which are well-known trademarks. For example, I quote my own name as an example. My name is, I did my Ph.D, I am Dr. Reddy. But by virtue of the Dr. Reddy Pharmaceuticals being considered as a well-known trademark, I can't put up my office name or the law firm name as a Dr. Reddy's. So likewise, if the mark is well designated as a well-known trademark, the person who wants to take up that particular name, even the person of the well-known trademark is not into that category of the services or goods. So you are barred from taking up that name as once it is designated as a well-known trademark. So these are the important parameters to be taken into consideration while making an application for the registration of the trademark to avoid the litigations. Because this is quite relevant when somebody has to take up for the arguments from the side of the defendant. You feel that these things, if you really strictly follow this, the litigation could be minimized. So then getting into the point, this is also one of the important slides from the point of passing off and infringement. Most of the litigation today we see, for example, if you register a trademark as a device or a composite trademark, the plaintiff, if he files a suit against the person who is the registered, if the plaintiff is the registered owner of the composite trademark, the mark cannot be dissected as per the Supreme Court dicta, and you can't have a monopoly rights over the independent element of the composite trademark or device mark. And you can't challenge against the defendant saying that defendant is violating the independent elements of the composite trademark. This is quietly covered under the section 17 of the Trademarks Act 1999. The reason that there are the types of trademarks are like word per se. A mark can be registered as a word as it is the way we write it up, the way we pronounce, it is the word per se. Second one, a logos can be registered, and also label consisting of the various elements and the artistic features of the labels can be registered separately as a trademark. And a device and composite mark, which I was discussing, is consisting of the various independent elements combined in one trademark as a composite mark. Maybe it is consisting of word per se, logo, label, and combination of all these things. So as held by the Honorable Supreme Court and the courts, various high courts from time to time, while comparing the marks as a composite mark, it should be considered as a whole and it cannot be dissected and compared for the purpose of deciding the trademark action of passing off or infringement. Accordingly, the signature can also be registered, and the shape of goods. When I say the shape of goods, the shape of the product can be registered under the Design Act, but the limitation under the Design Act is the 15 years, 10 plus 5 years. After that, it becomes a public domain. Accordingly, the one another aspect of registering, protecting those, the goods, the shapes of the goods is, you can make an application before the trademark registry for the registration of the shape of goods to get the lifelong, or as long as you renew a product for every 10 years. So latest addition to the Indian Trademarks Act 1999 is the sound mark and smell mark. All of you know, when you play Akashvani or Doordarshan, a kind of typical kind of music, it comes out when you in the initial stage of the, when you switch on the TV or switch on the the radio. So these are the sound marks of Yahoo, the kind of noise it makes when you click on the Yahoo. So these marks can also be registered as a sound mark, and accordingly there is also smell marks and different smells of the various fragrances of perfumes can also be registered under the smell mark. So these are the kind of marks which can go for the registration. So this is very relevant when you discuss about with regard to the subject on the point of passing off and infringement. So accordingly, just briefly, I will be going through the slides to know what are the stages of the registration, because the relevancy of the opposition and rectification would come into the suits for passing off and infringement. Whenever the application for the trademark is being filed, it is advisable to go for the search of the trademark on the trademark website at www.ipindia.nic.in. The search of the trademark is quite advisable for the reason that if you have a proper search of the trademark to understand whether any other persons are existing in the market with the similar type of trademark, maybe it is a phonetic similarity, maybe it's a deceptive similarity, and after understanding the availability of the mark on the trademark website, as a wise person, as an applicant or as an agent, as an attorney, can take a call on that, whether that particular trademark of the individual can be taken up for the registration of the trademark or not. I'm not going to discuss what kind of the filing of application and what is the kind of fees and all, because this is not the subject domain for discussion, at least today. And after the search of the trademark, if the individual decides to go for the registration of the trademark, the application can be filed with the consent trademark registry. When I say consent trademark registry, there are 5 registries in India. If the person is from Hyderabad, it is domain of filing of an application is the trademark registry, Chennai. At the time of filing of an application, some of the important precautions to be taken, because this will give you a scope for the litigation. The reason I say, if you are filing an application on the name of the partnership firm, the name of all the partners should be mentioned in the trademark application. Assuming for a minute it is wrongly mentioned and one of the partner is missing, and this could become one of the strong case for the person who will be filing a case against the particular violator or the imitator of the brand name in terms of passing off and infringement. And most of the cases, with my experience, goes to stay that people lose the cases more on technicalities rather than on the merits of the case. So that's the reason we are putting more pressure on these kind of slides to understand what are the precautions to be taken before filing before going for the registration of the trademark. The next is after filing of an application, examination report answering is the stage where examiner sitting in the trademark registry will be raising an objections by seeing the application. Again, they will cause their own search mechanism, and objection can be raised under section 9, absolute grounds for refusal, and section 11, relative grounds for refusal. And if any marks are international non-proprietary names as per section 30, or which are the marks coming under the Emblems and Names Act and so forth. After the examination application the query is raised by the registry is being answered. If the registry is quite convinced with the answers given by the individual or attorney or agent, then that application will directly go for the trademark journal publication. And if any queries further still exist, then there could be a show cause hearing. The individual and the attorney should argue the matter before the concerned trademark registry. Then if the registry is clarified or satisfied with the objection complied with by the particular individuals, then that application will be accepted or rejected at the stage of show cause hearing. If the application is accepted, then that particular trademark will go for the trademark journal publication. Here is the important aspect of one of the opposition to the trademark registration is whoever it is concerned with the particular trademark application which is being published in the journal, they can raise an opposition within 4 months from the date of journal publication. Then the opposition proceedings will take a longer time because someone has to file an opposition, then counter statement, then the evidences of the parties will be led, then the arguments would happen. After that, registrar has got the power either to reject the application or to accept for the registration. Then after this stage, the certificate of registration will be given by the registrar of trademarks. Then the certificate is valid for all other purposes. Then after every 10 years of the renewal of that application, the individual can withhold as a registered owner of the particular trademark. If no opposition is persist, the trademark registration process will normally takes not less than 6 months. It will be 6 to 1 year. Within 1 year, we will get to the registration application. And if the opposition is there, then that will take longer time, maybe 2 years, 3 years, or sometimes for last several years, many of the opposition's hearings are pending for the registry for consideration. Then, now coming to the subject now, what is this passing of an infringement? As GB Reddy sir rightly said, because there is there are a lot of judgments on this subject, and still it is a growing jurisprudence on this particular point of view. I want to put it in the simple terms of the passing of an infringement. The passing of action is more concerned about the unregistered trademark. Infringement concerns about the registered trademark. And I want to put in a nutshell about what is passing off. Suppose somebody is imitating the brand name of the other person, either with identical trademark or deceptively similar trademark, to create a confusion in the market, to encash the reputation and goodwill of the person who is the owner of the trademark, just to encash the business benefits like unjust enrichment. That action is called the passing off. Now, what is this infringement? But if the person who is the owner of the trademark who is being registered, and if his mark is being imitated by the public, the violators in the market, the very same action is as simple as called as the infringement. But what are the important requirements for this to decide the passing off is? This is the discussion has happened in Dharwad Industries Limited versus MSS Fruit Products, where this it is stated that the person who is using his mark shall be either identical or deceptively similar trademark. When I say deceptively, it includes the phonetic similarity, confusing similarity, and it could be otherwise creating confusion in the market. And most important aspect of this is imitation is just to create the unfair competition by misrepresentation. I'll give one example because Nirma versus Nima. If somebody copies the Nirma washing powder, a yellow washing powder, a girl dancing over the label, and if instead of Nirma it is R alphabet is taken out, if it is used as Nima, and the person who is imitating by name of the Nima, pushing his goods in the market, creating an impression as to that of Nirma. So that action is called as a passing off action. If it is the Nirma is a registered trademark, then that action amounts to the infringement of the trademark. Then what is the purpose of why at all someone has to do this? Because always the famous products in the markets are at higher rates because they spend a lot on quality and they spend a lot of amount on advertisement of the product. But if the person, somebody wants to imitate that product, he need not to spend all these amounts and he will sell those products at the cheaper rates by imitating the brand name as a deceptively similar trademark or identical trademark. That is, whole action is being done by the violators is to encash the goodwill and reputation of the plaintiff in the market and to create the confusion and deception in the market for unjust enrichment. So these are the basic requirements to establish whether for the action of the passing off and infringement. Now, what are the methods adopted for the passing off is? One is the false representation. See, so for example, a particular trademark is having that distinctive style of writing, and the person who is imitating the brand name may not be similar or completely different trademark, but even if you imitate the style of writing of the particular well-known trademark of the plaintiff, then that amounts to false representation. It could be a presentation of the label, it could be a presentation of color combination of the label, and even though name is different, that amounts to the colorable imitation. The false representation and colorable imitation is one of the reasons for the passing off. And third one is the copying of essential features of the trade name. And very interesting point is this, as per the Honorable Supreme Court judgment, the Supreme Court held that the Lakshman Dara and Amrut Dara, these both trademarks are similar in that particular case law. And whereas The Delhi High Court single judge has held that picnic versus picnic, PIK-NIC versus PIC-NIC, both are not similar. So it all depends upon the case to case and circumstances of the case and the facts of the case. It differs from case to. So that is all again the subject matter of interpretation. And what is the copying essential features of the trade name? That's what I said is that if somebody is violating the brand name, it need not to be identical or deceptively similar trademark. And also if you pick up some of the essential features of the whole appearance of the label or writing style of the trademark, then that is also amounts to the one of the method adopted for the passing off. And copying get-up or color scheme of the trade name, imitating the shape and design of the goods. Even not only the name, even if you imitate the shape and like water bottles are there are several water bottles available in the market. People if not imitate the brand name, they imitate the shape of the goods. And believe me, there are many trademarks which even every biscuit of the Britannia is being protected for the design. So people imitate the design and that also amounts to the passing off. See, basic intention is adopting the word or name of the rival trader to get into the action of the passing off and infringing the rights, even if it is for the registered trademark. Now, coming to the what are the tests for infringement? When you talk about the test for infringement is a higher pedestal because the owner of the trademark will get the statutory rights once the mark is registered. That's how the infringement action happens. And the test, one of the important tests is whether the two marks are identical. We will be discussing in the next slides. The Honorable Supreme Court in the Cadilla judgment, it has been decided that how to decide the similarity between the trademarks to come to a conclusion of the passing of an infringement. We'll discuss thereon. And where if the two marks are identical or deceptively similar, if not identical, the burden of the proof on the plaintiff, the person who is approaching to the court shall satisfy the court saying that their mark is being imitated by the defendant and it amounts to business loss. And the identicality has to be proved by the plaintiff. If it is not identical, if it is a deceptively similar, the burden is on the plaintiff. And plaintiff to prove the cause of confusion. The mere somebody approaching to the court saying that somebody is violating the rights by imitating the brand name does not make your case unless you prove the cause of confusion either by of third party affidavits or you purchase the sum of the bills or somebody has addressed you to the mail, addressed the mail to the plaintiff saying that the believing to that the plaintiff product, he purchased the defendant product and he resulted in some loss to him. So this kind of, the evidence to be placed before the court to establish that there is a cause of confusion. And once the matter is filed in the court, Honorable Court should look into the degree of resemblance as to that of the plaintiff's registered trademark as per the Cadilla judgment we will be discussing in another slides. And there should be resemblance to be phonetic or visual. It shall not be an identical. There should be, if it is a phonetic similarity also, and or visual similarity, or by seeing the label. Some of the most of the violators, they copycat the appearance of the label. Completely they copy the color combination of the label, but the name is different, but still that amounts to the passing of an infringement. And one of the most important aspect, as I told you with regard to the section 17 of the Trademarks Act, essential features as a whole. The mark should be considered as a whole and it cannot be dissected and compared. And the registered owner of the composite trademark will not get any absolute rights over the independent elements of the trademark of the composite trademark. So that's how the mark should be compared as a whole. There are several litigations. Of course, there are many which at least I am dealing are subject matter of judicial pronouncements. So I can't discuss at this stage. But there are many litigation even in Hyderabad with regard to name of the hotels or with regard to one of the examples which has become being diluted the Bawarchi. Today you find many of the Bawarchi hotels, yellow Bawarchi, green Bawarchi, yes Bawarchi, no Bawarchi and all those things. As long as the original owner is not questioning the validity of the registration, questioning for the rights for the trademark, then the trademark becomes diluted. Now, it is not the case of the only plaintiff will get a remedy from the court always. And what are the defenses available to the defendant in the case where the infringement case is filed against him? One of the most important aspects is the honest concurrent user. There could be the possibility that the plaintiff and the defendant are using the identical name at two extreme parts of India and none of the parties knows each other that other person is using that brand name. If both are using honestly for a long time, even after 10 years or 15 years, either of the party notices that other party is imitating the brand name. Under those circumstances, the courts permit both the parties to use the brand name subject to its limitations and conditions. And even the registrar of trademark, while considering the trademark application, can also impose the territorial restriction or some sort of conditions and limitations over the trademark which can be used and which cannot be used. And the registrar of the trademarks has got the power to put a conditions stating that a mark is registered as a whole and the particular applicant cannot have a exclusive rights for the one of the element of the composite trademark. So that's how both the trademark owners, even if it is identical, it is permitted to be used as a honest concurrent user unless defendant establishes that he has never intended to copy the brand name of the plaintiff. It was honestly being used for a long time. And second one is the trademark registered subject to conditions or limitations. As I told you about the registration of the trademark with the concerned trademark registry, the registrar has got power to restrict the particular trademark to particular area of in India, maybe for a district, maybe for a state, or maybe for a southern part of India or northern part of India, or with certain limitations and conditions saying that he can use the trademark so and so, but will not have the exclusive rights to particular elements of the trademark. So next one is assignment or license. Suppose the plaintiff files a case against a defendant wherein the plaintiff might have assigned the trademark or licensed the trademark to some other entity, then plaintiff will not have a right to file a case against the defendant. If the defendant is able to establish that kind of issue before the court, then defendant will have a defense against the plaintiff from the suing from the infringement. And plaintiff has no title to use. The plaintiff, for various reasons, by way of court order or by way of assignment or by way of license, if the plaintiff do not have a title to use the brand name, then that is also one of the defense for the defendant. Defendant user is prior to that of the plaintiff. Now, this is one of the most important aspects of all the intellectual property rights. The prior user and prior art is at higher pedestal than the registered owner. For example, a particular name is not registered, but the particular person is using the brand name for imagine for a minute, last 20, 30 years. If other person has got the registration of the trademark for last 1 year or 2 years, the question arises, who will be having the better rights than the registered owner? A better right over the trademark. It is affirmatively, it is on the person who is using for a long time will have a better title and better rights than the registered owner. Now, whether the registration of trademark, if it is not valid for whatever the reason, then that becomes one of the defense for the defendant in the suit. And another aspect is acquiescence. Acquiescence is section 33 of the Trademarks Act 99. What it says that if somebody is wants a person of using the trademark and he did not take the action for next 5 years, and if he files a suit after 5 years, that becomes one of the strong defense for the defendant. Say that because and delay and latches also. Just because of delay, latches and acquiescence, if the plaintiff is negligent in taking the action against the registered action against the defendant, then defendant will have a defense under these three aspects of delay, latches and acquiescence, because intentionally plaintiff has warned the person who is violating the rights. If the reply notice is given to that, but the plaintiff do not file a case for next 5 years, or at the later point of time if he files, that becomes one of the strong defense for the defendant. One another aspect to be discussed is, unlike any other laws in India, the intellectual property law with regard to trademark and copyright, where there is something like groundless threats of legal proceedings. A person, if he keep on giving a notices, if keep on giving a warnings and not filing a case against the defendant, then the person who is being issued with the notice can go to the court saying that he is being given the threats of groundless threats of legal proceedings, and thus he can seek the remedy of the filing a case against the person who has issued a notice to not to file the case against the defendant bona fidely, and giving a notices is being stalled. But the law is very clear on this. Judicial presidents of the various courts, once the 142 application is filed by the defendant, if the plaintiff files a case of suit for infringement, then the suit filed under section 142 becomes infructuous. Now, what are the basic differences between the passing of and infringement? This aspect has come in, is being discussed in one of the judgment of Cadbury India Limited versus Neeraj Food Products. The passing off is a common law remedy as per the section 27 of the Trademarks Act 1999. A remedy is available for claiming the damages against the violators, and infringement is a statutory remedy where the registered trademark, the person who has got the registered trademark can seek the remedy of infringement from the court of law for the injunction and other reliefs. And registration of the trademark is not essential in the case of passing off, whereas in the case of infringement, registration of the trademark is required. Now, in the case of passing off, burden is on the plaintiff to prove the deception and confusion, as we discussed in the earlier slides, and in the infringement, presumption of the confusion. If I'm not wrong, I think Section 31 of the Trademarks Act 1999 clearly says that the registration gives the evidentiary value for the to conclude in the courts to as a registered owner is you need not to file any other documents if the registration document is being filed in the courts. Now, in the passing of criminal remedy is relatively harder, and whereas in the infringement, a separate chapter is being defined to seek a remedy against the violators once the mark is registered in favor of any entity. That is, the criminal remedy is easier. One of the most important aspect of the intellectual property rights of the trademark law concerned is that the jurisdiction of the court is very important. The intention of the legislature for incorporating the Section 134 and 135 of Trademarks Act 1999. Prima facie, it is one of the extraordinary provision given to the plaintiff who has got the registered trademark. He can file a case wherever he has got the business partly or fully, or he is in the full main office or branch office. From the place he can file a suit for infringement. And in the case of, I'm sorry, the jurisdiction of the interrelated infringement should come to the jurisdiction of the court in 134, and Section 20 of the CPC governs for the passing off. In the case of passing off, if the registered trademark is not registered, the suit to be filed at wherever the defendant resides as per the Section 20 of the CPC. I'm sorry, these two are interchanged in this. So now this is as we are discussing about how the similarities can be decided in the courts with regard to the passing off and infringement. Is one of the most important aspect is while comparing the trademarks of the plaintiff and the defendant, the court should look into that whether both the marks in the case are word per se, or label, or logo, or composite marks. So accordingly, suppose a person who is having the plaintiff having the composite trademark files a case against the defendant saying that one of the element and independent word of the composite mark is being violated by the defendant, that becomes a weak case for the plaintiff to say that, because as long as independent elements of the composite mark are not separately registered, the suit cannot be filed against the defendant with the claim that unless the part of the trademark is having attained the secondary meaning and it is being very famous in the market. Now, second issue is the degree of resemblance. What is the kind of resemblance between the trademarks? Whether there is a phonetic similarity, or whether there is any confusing similarity, or the marks are identical in the market, and these things to be taken into consideration by the courts. And the third one is the nature of the goods. And this particular judgment was with regard to the pharmaceutical products. When I say about the nature of the goods, suppose, for example, a particular brand name is designated for the allopathic goods, and identical brand name is given for the veterinary goods in the Class 5 of the Trademarks Act 1999. Then the nature of the goods to be taken into consideration and in accordance with the class of purchases. Suppose if the class of purchases is the one is for veterinary and another one for allopathy, the availability of the goods cannot be from the same source, then the case accordingly can be decided whether there is any confusion and deception could be happening in the market. And when I say the class of purchases, this particular case is, as I said, it is a pharmaceutical product. There is something like Schedule S drugs. As per the Schedule S drugs of Drugs and Cosmetics Act, drugs cannot be prescribed across without the prescription of the doctor, cannot be made available at the medicinal counter. But unlike this in India, with because the kind of, when you go to the medical shop, any kind of medicine is available when you name it. But you go to any other countries, because it's very strict, unless the Schedule H drugs, the drugs which are being put in the category of Schedule H, without the doctor's prescription, those drugs are not made available. Unfortunately, there are kind of judgments wherein says that many people know what is the kind of the writing the doctor do. There is a possibility of getting one drug is given for another drug. And in another judgment, wherein it is said that it is a duty of the doctors to write very in clarity so that there should not be any confusion. But when the matter comes to the Schedule S drugs, if the one of the drug is out of the Schedule S drug is similar to that Schedule S drug, if one drug is given to another drug with little dissimilarity, then there could be a disastrous consequences. A person may die also. So accordingly, because there's a kind of interpretation, there are kind of judgments which have come up, a jurisprudence is evolved in this, and so forth. This is one of the class of purchase to be taken into consideration while deciding the fact of, similarity between the marks. And another one is the mode of purchase. And see, nowadays it is online also, you can purchase the many goods, and that is also to be taken into consideration. Nowadays, Amazon is very clear, because unless the mark is registered, they don't accept the goods to be sold from their forum, to avoid all this kind of litigation, because the many people do, even Amazon also party of the one of the defendant to, for many reasons. And another one is the surrounding circumstances. Next, this is one of the very important aspect, because the evolution of the jurisprudence in this particular aspect of intellectual property law is very, very interesting. What are the types of reliefs in case of infringement? Section 135 is very clear, and it is also defined what are the kinds of reliefs you can seek from the court. One is the damages or account of profits, and second one is the order of delivery of infringing the label and marks for destruction and erasure, and injunction restraining a further use of the infringing the mark, that is a permanent injunction. And next is the order of injunction in the terms of temporary injunctions. We'll be discussing the different kinds of orders, which is the evolution of the jurisprudence in this particular concept of the intellectual property rights. These are very, very important. And of course, every one of us know about what is interim injunction and permanent injunction. Normally you file for the conventional cases like the civil litigations and other litigations, where interim injunction is being granted by the court when the court is satisfied prima facie case, balance of convenience and irreparable loss as per Order 39 Rule 1 and 2 of the CPC. Pending suit litigation, courts have got the power to grant the ad interim injunction and interim injunction. I need not to elaborate on this point for the point of time constraint. And second one is the permanent injunction, and after the elaborate trial and the documentary evidence and the strength of the case, the complete usage of the particular brand is being granted by way of permanent injunction. In addition to that, whatever the damages you can claim, we will discuss in the earlier slide. And one of the most important aspect is that I discussed, because John Doe order. What is John Doe order? This is order against the unknown defendants. Now, take the example of one of the famous movie which has come, the Bahubali. Now, Friday when picture releases, Saturday morning you get a pirated CDs which is having the more clarity than the original CD sometimes. Now, is it possible for the person who is the film producer to run around the violators who are spread over all over India, and he has to file the cases running around the places all over India, and it is quite impossible. Under those concepts, it is evolution of this kind of orders. Is John Doe order is you can file the suit against one of the defendant whom it is known. Then John Doe could be the other defendants who are all violating. This is something like order in rem rather than order in personam. When the order is passed by the honorable courts against one of the defendant, that order is equally applicable against all the defendants all through the world spread over, and this order can be taken into implementation by the help of the police to stop piracy of the most respectfully. This particular order is invited in the copyright matters. And there is another important evolution in the jurisprudence is the quiet action. Now, this is what we know to the law is that if you want to intend to file a case against the violators, you should have a cause of action saying that particular person is violating your rights, and this is the cause of action, or particular bill you produce and all those things. But is there any possibility if you go to the court saying that somebody is intending to create harm or intending to violate the order in the future? Yes. Now, recently there are many pharmaceutical industries have invited this kind of orders. This kind of jurisprudence is available and known to the honorable courts. Now, this is the case. Suppose, for example, a defendant is intending to violate the order, saying that he is intending to launch so-and-so product, he put it on the webcast or on the website. That itself creates the cause of action, even though the particular product is not put into action. Under those circumstances, the orders are invited under the concept of the quiet order. And there are the two other important orders. One is Anton-Pillar order and Mareve injunction. Of course, Anton-Pillar order is to inspection of the premises in addition to the injunction orders to be granted by the court in order to, when the people are intending to damage or cause the evidence to be destructed, under those circumstances, with the help of the police, court can order the ante and pillar order. Those premises could be most happened to in the matters of the computer piracy and all. All those computers can be seized from the premises, inviting the order from the court. This is ante and pillar order. And next one is the Mareva injunction. This is to freeze the defendant's assets, to keep safe, to decide the case ultimately in the final adjudication by in the trial and appreciation of the documents. Now these are some of the important orders which are evolution of the jurisprudence, where it is only possible in the kind of intellectual property rights, unlike the conventional practice we file the applications in the civil disputes and other disputes. With this, because one thing I want to put it in everybody's knowledge, because there is the judgments of the Honorable High Courts and Supreme Courts, one of the important aspects which come into consideration is that there are judgments which says that, especially intellectual property rights, there are judgments which says that interim orders to be avoided because the speedy trial to be conducted. In the matter of the Bajaj Auto of the Honorable Supreme Court, given the dictum and all the courts in India is being stated that in the matters of the intellectual property rights, normally the multinational companies or the powerful owners of the brand name, they invite the ex parte orders, and the matter it is very difficult to, when the ex parte order is passed, it is very difficult to vacate the orders, and under those circumstances, so it becomes a kind of pressure tactics on the defendant to settle the matter. That's how the Honorable Supreme Court in the Bajaj Auto case has stated that all the directions given to all the courts in India that these kind of matters to be closed within 6 months of time, and it is quite practically impossible with the situation we are dealing with now. And second issue is that what I want to say, the courts of our High Court, Honorable High Court for the state of Andhra Pradesh, at that point of time, one of the judgment, it is stated that it should be looked from the defendant point of view rather than the plaintiff point of view in the matters of intellectual property rights, for the reason that if the plaintiff succeeds in the suit, he will be compensated because he will be claiming the damages. And second issue, if the plaintiff loses a case and defendant succeeds, having suffered the ex parte injunction or interim order for almost 2 to 3 years in the past, who will compensate the defendant is another way of thinking of the jurisprudence. And this is the evolution of the law, and there is a very big vacuum to fill up this law by kind of judgments in the future courts we are anticipating. And with this, I'm sure I covered this topic to the best of my knowledge. And thank you once again for the Dr. G.V. Reddy Garu for giving this golden opportunity to share my practical views. And really, sir, this subject is so elaborative and it is very difficult to cover it in 45 minutes. Thank you so much.
Thank you, sir. Now I request Mr. A. Srinivas to please propose vote of thanks on behalf of the DPIIT-IPR Chair.
Good evening, one and all. Good evening, sir, and good evening, all the participants. Sir, it was a wonderful session. I must thank you wholeheartedly. And secondly, sir, thank you for gracing this today's evening with your practical knowledge and enlightening us with all the key topics which is relevant to the trademark. So you have supported us on meeting up our objectives, sir. So which is like promoting IP temper among all and disseminating the knowledge for everyone. And the topic also which you have selected was a niche topic, I must say that, which most of the professionals and practitioners also gets confused about the topic and its issues. So, but you have lucidly explained all the key parameters, sir. Thank you for that right explanation to everyone. Thank you, sir. And I would also like to thank DPIIT Chair Professor and the organizing team and all the participants for making each and every session and episode successful. So, which was the key objective of this DPIIT-IPR Chair. So I would conclude this session by thanking everyone who is participating here and also who is viewing our channel. So I would request everyone to please subscribe to our YouTube channel, wherein we are uploading all the relevant videos which are related to IP for promoting IP culture. Thank you, one and all. Thank you.
Thank you, sir.